The sting of tear gas, the cracked pavement, the absolute exhaustion of standing on the front lines for hours, only to wake up the next day and realize the system hasn't budged an inch. It is incredibly disheartening. You showed up. You submitted written memoranda during the required public participation phases. You played strictly by the rules, and the government still rammed unpopular laws down your throat. Article 37 of the Kenyan Constitution explicitly protects your right to peaceably assemble and demonstrate. Maandamano is a guaranteed baseline right. But as a primary tool for systemic change, it is a blunt instrument. It takes a massive physical toll on citizens and bleeds the local economy dry every time businesses have to board up their windows. Which brings us to a highly practical question. How do we build a first-world economy if we are constantly relying on the most disruptive, exhaustive methods of street-level feedback? The 2010 Constitution is a highly engineered, offensive armory. Its specific provisions provide the legal machinery needed to dismantle state overreach through direct, surgical action. To actually win these battles, we have to transition away from the sheer noise of the streets and start deploying the state's own legal blueprint directly against it. Look at this placard from the 2024 finance bill protests. The hashtag printed right there on the cardboard shows the first step, moving the fight off the pavement and into the digital realm. Consider this the digital picket line. Citizens are now using AI-powered civic tech apps and custom GPTs to translate dense 300-page policy documents into clear, bite-sized facts that anyone can share instantly. When you can parse the government's own budget data faster than they can spin it, you strip away their monopoly on information. Out-knowing the state is a far more effective negotiation tactic than simply shouting at them. But information needs a target to hit, and that target sits right here at the National Assembly and the Senate. This brings us to weapon number 2, the Article 119 petition. This is a specific constitutional right, guaranteeing that any person can petition Parliament to enact, amend, or repeal legislation. It is a direct command from the citizen to the state. Look at this official petition form. It triggers a 60-day legal countdown for Parliament. See here, it demands confirmation that you've already engaged the relevant body, forcing the legislature to officially acknowledge your documented facts and the government's failures. A street protest leaves temporary footprints that wash away with the next rain. A properly filed petition forces the government onto a legally binding countdown that they cannot disperse with riot police. Of course, the legislature is only half the problem. The daily friction most citizens face happens deep inside the sprawling administrative bureaucracy, such as the delays, the abuse of power, the sheer unresponsiveness. The legal term for this is maladministration. To fight that, you use weapon number 3, the Commission on Administrative Justice, commonly known as the Office of the Ombudsman. The Ombudsman has the legal mandate to investigate and penalize improper conduct by state officers. Filing a hyper-focused complaint here bypasses the need to gather a crowd. It strikes directly at the specific official bottleneck causing the problem. But when the bureaucracy refuses to correct itself and the legislature passes bad laws anyway, the battlefield shifts here. This is weapon number 4, the nuclear option. Under Article 22 of the Constitution, every person has the right to institute court proceedings if a fundamental right is denied or threatened. This is known as public interest litigation, or PIL. And crucially, you do not even need to prove personal injury to file one. We have seen this exact tool dismantle state overreach. Look at the Building Bridges Initiative, where the courts halted a massive constitutional amendment process, or legal challenges that blocked the Huduma Namba digital ID rollout over severe data privacy concerns. The leverage here is immense. A handful of well-prepared lawyers, armed with a single court injunction, can legally paralyze billions of shillings in unconstitutional state action overnight. You do not need 10,000 citizens throwing rocks to stop a bad law or a corrupt megaproject. You only need one surgical, meticulously researched constitutional injunction. There is a persistent myth that using official government channels is just playing nice with a rigged system. That if you submit paperwork instead of taking to the streets, you are somehow conceding defeat to the bureaucrats. Deploying this legal blueprint makes a citizen dangerous to the state. It forces the government to defend its actions in a forum where riot gear and tear gas have no jurisdiction. By shifting the arena from the streets to the courts and the tribunals, you strip the government of its primary advantage, physical force. You drag them into an open, paper-based war of attrition, where their inefficiencies, their poor planning, and their legal overreach are completely exposed. So draft the Article 119 petition, submit the ombudsman complaints, work with civil society to file public interest litigation, and use AI tools to process the data they try to hide in the fine print. Wielding the Constitution as a scalpel allows citizens to out-negotiate the state. It transforms the law from a distant ideal into a practical, everyday tool for enforcing accountability.